May I proceed, my lord?
Yeah.
On page 14, paragraph 5.9, cell phone evidence and downloads. I will start with the evidence given by Colonel House. Calls between accused number 4, who is the applicant before court. Accused number 4 contacted accused number 1, Mr. Sibanda, 14 times. Accused 4 contacted accused number 5, 127 times. Accused number 4 contacted accused number 5 again on a different number 2 times. Accused number 4 also had contact with accused number 3 48 times. Accused number 4 had contact with accused number 1 again on a different number, only once. Lieutenant Colonel Host testified that the number belonging to accused number 4 was also saved as a contact on the SIM card of accused number 5. It was saved as Mapisa. This information was verified that the number belonged to accused number 4 by the fact that the phone was recovered on him in lieu of prison during an arrest, and also by way of section 205 that was brought by the Vodacom personnel. Furthermore, exhibit EEE, which is the bank statement of accused number 4, also confirms that the number belongs to accused number 4. Paragraph 5.10, bank statements of accused number 4. Exhibit EE, the 2 transactions on the date 26 October 2014, where the accused before court made a transaction at Malvern Ultra Liquors. My lord, contrary to what the defense said regarding the exhibit, the state did not produce this exhibit to show that money was paid into the account, but the exhibit was to show that the number belongs to accused number 4, as well as the fact that accused was near or at Fostoras in the date in question.
What date was it, by the way?
26 October 2014.
So all these phone calls take place on one date?
No, my lord.
Or different dates?
On different days. And not on the 26th of October, but after the 26th of October, my lord.
Okay.
Yes. But the transaction, the bank transaction, it took place on the 26th of October 2014.
Let's see.
Paragraph 5.11, Jack Buthelezi testified that Ntanzi, accused number 2, he said that he was going to appear in court. He then said that Mr. Buthelezi should come and see him at court. They have to meet, and Buthelezi asked where exactly he was. He said he was in the vicinity of Absa or near by Absa. He then proceeded to that spot. They met there. He asked Bongani Ntanzi what was happening, and accused 2 said he was arrested. Buthelezi asked him what. That's when accused 2 responded by saying that he had been arrested. Bongani Ntanzi said to Buthelezi that he has been arrested in connection with the matter in possession of ammunition, and further that he is accused of, or that he is arrested further in this Meyiwa case, that we had inflicted injuries on him. That is the Fostoras case, and that they were, then Bongani Ntanzi said that they were at the party, and he said that he was in the company of his friends. He said it was Mapisa and them when he referred to his friends. Then Buthelezi took out 500 from his pocket and gave it to him. Paragraph 5.12, execution of J50 warrant of arrest. A J50 warrant of arrest was executed on the 26th of October 2020 at Lukop Prison by Brigadier Gininda, being the lead investigating officer in this matter. According to the evidence of Lieutenant Colonel Gideon House, Exhibit DD5B, the day of the execution of the warrant of arrest, accused number 4, Mr. Mapisa, contacted Mtobisi Nube, being accused number 3, 3 times on the day. Furthermore, Mapisa on the 26th of October 2020, contacted Fisekohle Ntuli, accused number 5, once. Furthermore, on the 27th of October 2020, now being the date of the first appearance before the magistrate court in Boksburg, Mapisa contacted accused number 3 times, and Mapisa further contacted Fisekohle Ntuli only once. These accords with the evidence of Colonel Gideon Kous. Furthermore, it was put to various state witnesses such as Ms. Pinky Fillingham, Sergeant Mabasa, Brigadier Gininda, that accused, I think there's a typing error, accused number 3, 4, and 5 were together on the 26th of October 2014. Exhibit S and Exhibit G1 places the accused 3, 4, and 5 together at or near Fosslores.
What is it in the photographs?
The photographs, my lord, as well as Exhibit G1, which is the cell phone record of accused number 3, wherein, and I want to amplify this point, my lord, wherein Mr. Ngumalo, on behalf of accused number 4, said he aligns himself with the cell phone records of accused number 3. And then I'll revisit this point at a later stage.
He aligns himself
with the cell phone records of accused number 3, being Mr. Ngobe.
Okay.
So that's briefly the summary.
All right.
Then I will deal now with the heads of arguments of accused number 4 to respond to some of the paragraph 31. And the heading there is re-defense heads on behalf of accused number 4.
Yeah, on paragraph 31.
Indeed so, my lord, on page 31.
Is it page 31 of paragraph?
Paragraph 31, page 31.
Okay.
The state is not going to respond to every submission. However, the fact that any submission has not been dealt with should not be regarded as not being challenged. Paragraph 3.1, at paragraph 6.4, section 144, subsection 3A states that where an Attorney General, now Director of Public Prosecutions, arraigns an accused for summary trial in a superior court, the indictment shall be accompanied by a summary of substantial facts. Section 144, subsection 3, Roman figure 1, provides that this provision shall not be construed that the state shall be bound by the contents of the summary. Sneeman, in Sneeman's Criminal Law 7th edition 387, defines murder as the unlawful and intentional causing of death of another human being. At page 169, he states that intention must not be confused with the motive for committing a crime. In determining whether acts acted with intention, the motive behind the act is immaterial. Paragraph 3.31.2, corresponding paragraph 6.4.5, Colonel Stein testified that when downloading the cell phone, you must always add 2 hours to the time mentioned in the downloaded information. For example, if 07R00 will become 09R009. And this can be found on record dated 27 July 2023 on page 69. Paragraph 3.31.3, response to paragraph 6.4 and 5 and paragraph 6.4.6. The state submits that the source of the data in which the communication between Kelly Kumalo and Fisekohle Ntuli was found is the cell phone download done by Captain Mushwana. And the device type that was downloaded is a ZTE V795, and the IMEI number also appears on page 31, and it belongs to Miss Kelly Kumalo. Page 32, the paragraph 31.3 proceeds on page 32. Captain Mushwana testified that on the 27th of October 2014, he received a telephonic request for assistance from Lieutenant Colonel Nisling, as per Phosphorus case 63610-2014, to assist in downloading the data from the device ZTE V795. The cell phone belonged to Ms. Kelly Kumalo. Furthermore, Captain Mushwana testified that on the 28th of October 2014, he handed all the exhibits to Constable Mahlaba from head office by the directive of Brigadier Ndlovu. No data manipulated during the extraction, and all data was copied to a CD. This can be found on the record. Pardon, my lord?
Was it a PFD or a CD?
On a CD.
CD, okay.
Yes.
So all of it, it's not like part of it.
All the data was placed in a CD.
Because they said that it wasn't sifted, and you guys know that it can be manipulated.
But the witness said it cannot be manipulated.
Okay.
And this can be found on the record 11 August 2023 on pages pages 5 to 11. We submit that Captain Mushwana authenticated the data by indicating that this is a case data report that he had downloaded from the device. I think this is what the Learned Judge was getting to. The face of the details of the exhibit that was handled as to the case number, where the case was reported, as well as the forensic bag number. The details of the case operator, which will be Captain Mushwana, where he confirmed. Record 11 August 2023, pages 11 to 12. Response to paragraph 6.47 of the heads of arguments of accused number 4. We're on page 31.4. The state submits that Ms. Pinky Fillingham explained the difference between the set of data that directly comes from NEMO and the cell phone downloads. The witness further testified that you cannot differentiate between a call or a message under the GPRS data because it is internet usage. Under the GPRS stream, it is all the internet-related activities, that is, whether you surf the net or use WhatsApp to make a call. Back in the day, it used to be BBM, which could fall under GPRS. The witness reiterated that you cannot differentiate under GPRS stream whether it's a message, whether you were streaming, or whether you have made a call. All it shows us is the usage of that transaction. Record dated 3 June 2024 on page 51. My lord, this is very important because what now the defense has submitted is to look into the NEMO. NEMO is twofold. There is the normal calls and there is the GPRS stream. And the state submission is that the call that accused number 5 and Ms. Kelly Kumalo were involved in, it's a GPRS stream. On the other hand, the defense is zooming into the what we call the AMA data, meaning the normal calls, ongoing, outgoing calls, and SMSs. You cannot find the information there, but the information is on the GPRS stream. And then within the GPRS stream, you cannot differentiate whether it's a message or it's a call. What you see is just internet usage. So that is our submission.
So there's no fraud, like it was put to...
There's no fraud, my lord. You can only submit if it's fraud if you look at the wrong side of the document. If you look at the metadata and then you say it's fraud. But if you look at the GPRS stream, then you find corroboration.
But in any case, how many pages were there? 36,000? Part of the record, I mean, of those.
It's a lot of pages.
It was 36,000. So
in
according
excess
to
of
the
40,000 pages there. Yes.
yeah, according to the submission only 2 numbers were forged out of the 66,000 pages plus of the,
Indeed so, my
of,
lord.
the, of the numbers. Only 2 numbers,
2 numbers and 2
according
days.
to the defense, were forged
And only on 2 days.
on 2 days.
That's
Okay.
correct. Furthermore, my lord, Colonel Stein testified and confirmed that there were communications between Kaylee Kumalo, a cell phone number 0827044358 with accused number 5, and which is Nkani, accused number 5. The number 0733059202 on the following dates: 3 August 2014 and 15 August 2014, using internet. Oh, October, my lord. August and October 2015, my lord. 2014, rather. Using internet, which will not appear or show on normal section 205. You can only get it by downloading the phone if it is available. Blackberry.net, which he also made reference to, it meant that she was using data.
And it doesn't operate through the internet.
Blackberry.net operates on the internet.
Yeah, sorry, yeah.
Yes.
The other way.
That's correct, my lord. And this can be found on the record 12 August 2024 on page 50. Paragraph 31.5, response to paragraph 14.3 and 4 and 14.8. The state submits that the presence of Constable Zungu, and I want to highlight this point, my lord. Yesterday, during interaction between the court and Mr. Ngomalo said never, there's no corroboration. And in the state submits this corroboration, enough corroboration. The presence of Mr. Zungu at the hostel can be corroborated. The presence of accused number 3 and number 4 can be corroborated by objective evidence that was brought by Ms. Pinky Fidingham before this court as exhibit GG1. On the 26th of October 2014, from 1341 to 1511-33, accused 3 and 4. And I'm including accused number 4 because he said he aligns himself with the cell phone records of accused number 3. He even amplified it to say that whenever accused number 3 receives or makes a call, he will be there to see that this person was using this device. And whenever there was a photograph that was to be taken, the only person that will take the phone and take a photograph was Mabungu Ntuli. That's accused number 4, through his counsel. And then we submit, my lord, that according to the data around that time, the tower reflected is phosphorus. How do we know that, my lord? Because Ms. Pinky Fidingham told us that the phosphorized tower, it resides at or near, I want to use those words, Basuti Hostel. It is 688 meters. And then how does a tower works? You connect to the closest available tower. So how is it possible that accused 3 and 4, they were at Lisedi, where we know there's a tower, and if the Lisedi tower is not working, then there's a tower nearby, which is Phosphorus West. Why were they not connecting to Phosphorus West or Lisedi if they were indeed at Lisedi? And our submission, my lord, is they were at Basuti Hostel, which is 688 meters away from the tower. That's why they were connecting to the Phosphorus Tower for those over 3 hours. And we submit that that is the time where this planning to kill the deceased took place. It is the time wherein the state witness, Mr. Zungu, said he saw them during the day. Even at the time when accused number 5 were to leave, he has to make way for him to reverse for him so that he can leave the hostel. And this information, my lord, can be found, or this evidence, 29 July 2024 at page 54. The witness also, Ms. Pinky Fidingham, also gave the distances between Basuti Hostel as well as the Lisedi Tower. Pardon, my lord?
Is it the house or the scene of the crime? Pinky. Did it give the dimensions between so-called Basotho Hostel and 1135?
She did give the distance as well, my lord. I think it was between
Yeah, fine. I'll get it.
4 kilometers, somewhere around there. But there's a map with the
4.3
distances.
4.3
4.3
kilometers.
That's correct, my lord. I think that's my recollection.
He
as well.
actually said if you must get there, you can't use skates. You can only use a car. You remember I saying that?
Indeed so, my lord.
This old man doesn't forget.
And then furthermore, what is important, my lord, is that Pinky Fifilingham says the tower coverage in an urban area such as Westlaras is between 500 meters and 2 kilometers.
Yeah. So,
Because it's a built-up area. And that can be found on record 12 June 2024 on page 11. Paragraph 31.6 on response to paragraph 4.7 of accused number 4's application. Constable Zungu testified that between 8:30 in the evening as well as 21:30 in the evening, he saw accused 1, 2, and 3 coming and following each other. And it had been some time he has last seen accused 1, 2, and 3. That it's on the record dated 7 September 2023 on page 14 and 20. Colonel Stein and Ms. Pinky Fifilingham testified that the robbed cell phone, now that is a cell phone that belonged to Ms. Kelly Komalo, from the scene, which is Putwanong Street, picked up or connected to a Mulileki tower around 21:52:56 seconds on the 26th of October 2014.
yeah, just wait. So the date actually coincides with the date of the alleged murder.
That is correct, my lord. Few minutes later. Yes.
Because it was argued that it's not the same by Mr. Muman. It's not the same cell phone. Hey, the color is white, it's this and that and that and that. Identity was being disputed.
Of the cell phone that was robbed from the scene.
Robbed. Mr. Baloi called it the robbed
Cell phone.
of Mr.
No,
Kinenda.
but according to the independent evidence brought by Vodacom, this cell phone from the crime scene, it connected to the tower in Moleleki, and then Colonel Stein said this Moleleki tower is at or near the hostel. I'm avoiding to use the word vicinity because it's broad, so it's at or near the hostel. And at that time, whoever that was inside the house at Kutwano was at the opposite direction, was at the clinics, was picking up the clinics tower.
So it moved the cell phone.
The phone moved, and it moved at or near the hostel. And we have Constable Zungu that places all the accused persons after 9 in the evening at the hostel, after he has not seen them for quite some time. Paragraph 31.7, it's a response to paragraph 14.9. Constable Zungu testified that he took the 38 special from Muzi and looked at it, and they were handing these firearms over to Gwabeni. That's found on record dated 7 September 2023 on page 18. Paragraph 31.8, response to paragraph 14.14. Constable Zungu testified that he knew accused number 4 from Fuslores, not from back at home. He further testified that on the 26th of October 2014, accused number 4 arrived, and on his arrival, he gave Zungu the car keys and he also conveyed his gratefulness.
So Zungu's car is submitting, otherwise, did it move or it never moved?
We do not have such evidence, but what we know, my lord, is that his car keys at some stage, they were not in the bag in which he has initially placed them. So when he was about to leave, then he looked for his key, he couldn't find them, asked Gwabini to check. Gwabini then made phone calls. Then Zungu was told that accused number 4 is coming back with the case. And then he came back, he handed his car keys to Mr. Zungu, and then accused number 4 conveyed his gratefulness by the manner in which he handed them back to the witness. The state submits that Constable Zungu testified that both Gadla, accused number 3, and Muzi were carrying firearms. They had firearms. Mafika was the only one who did not have a firearm. Accused 3 had a 9mm. I've already mentioned the fact that there is some corroboration in the 9mm that accused number 3 was having on the date in question. Colonel Mangena, Warrant Officer Rolofse, Musia recovered a projectile that can only be produced by 9mm, as well as Colonel Muslasho. When we handed in the ballistics, the projectile as well as Exhibit 1 for examination to the defense witness, he also confirmed that those projectiles can only come from a 9mm, my lord. So we submit this indeed corroboration when Zungu said that accused number 3 was armed with a 9mm. 31.9 at paragraph 14.21, Constable Zungu testified that on the 18th of November 2019, he saw 2 people who were in the vehicle who tried to shoot him, and the one was Nkanzimulo. He's a relative of accused number 1. The incident took place in Tembisa. That is on the record of the 7th of September 2023 on pages 47 to 48. Brick Gininda testified that Muzisi with cell phone number 07937900137 had contact with Constable Zungu with cell phone number 0769799528. The tower, which is Wesselton in Mpumalanga, the date thereof was 19 November 2019.
Wait, just take it slow. Is that accused number 1?
That is accused number 1 now.
Well, he denied that, you remember Zungu said they spoke at a wedding of the sister, whatever.
That's correct, in Nango.
And then somebody came and disturbed them.
Then they stopped.
And then they decided, right, so they cover in future.
That's correct.
And then, according to Zungu, not me, Zungu says then he told, the other way, accused 1 told him that he'll be going to Mpumalanga.
That is correct, my
Am I correct so far?
You are correct, my lord, 100% correct. That is the evidence.
So the telephone records, whose telephone records appear in Mpumalanga and whose appear out of Mpumalanga, according to your submission now?
According to my submission, my lord, the telephone records that we have is of accused number 1.
That's it?
It picks up his tower in Mpumalanga. And the other person that is being contacted or is making contact with him is Constable Zungu.
Okay.
Simple as that.
Yeah.
We do not have the telephone records of Constable Zungu, but we are relying on the cell phone or data of accused number 1.
Okay.
And then Mr. Zungu, on the date when he says they tried to shoot him, he makes mention of a person. He said his name is Nkanzimulo. And then what Mr. Mnisi does on the 28th of October 2014, on the 11th of June 2025, put it to now, Warrant Officer Ndlovu, that the person that took a photo depicting accused number 1 wearing a red shirt and a jean standing next to a vehicle was a person called Nkanzimulo. So there's some sort of corroboration in what Zungu says, that the person that happens to have wanting to kill him to be a relative of accused number 1 is confirmed by what accused number 2 puts before the court.
So it's not denied that there's a human being called Nkazimuntu
Exists, yes.
who exists.
Yes.
And apparently, according to Zungu, that's the gentleman who attempted
to kill him or to shoot him. Don't know what was the purpose of the shooting. Maybe wanted to scare him.
He only mentions one name, Zungu.
Mentions two names. Say
The other one, is it an
Ntuli,
uncle or what?
uncle of accused number
Who's supposed
1,
to be a,
relative of accused number 1 and 5. The other person is Ntuli person, relative of accused number 1 and number 5.
okay. Yeah.
Paragraph 31.0 or 10, response to paragraph 14.22. Constable Zungu testified that they went to Tops together with accused 3 and 4. There was a certain shopping center there. They bought liquor. They then went back to the hostel. That's on record 7 September 2023 on page 10. Paragraph 31.11, response to paragraph 15. As indicated in our heads, credibility plays no role at the section 174 stage unless the evidence of the witness can be said to have been utterly destroyed. We submit that it can be said that Constable Zungu's evidence has been destroyed. It must also be borne in mind that as it was, cannot be said it was utterly destroyed. As it was held in Peter's case, referred in our heads, the court can accept certain portions of a witness evidence whilst rejecting certain portions. The role that accused number 4 played is set out in the extracurricular statements of accused number 2, being present when there was a briefing at the hostel to kill the deceased, received the firearm from Simpiwe and handing them to accused 3 and the other accused, acting as a lookout and positioning himself at the window of the Kumalas, running into the house after the deceased was shot and after they had departed the scene and returned to the hostel, asking accused number 3 if he is sure that he had killed the deceased. Paragraph 31.12, that paragraph.
Yeah, sorry to disturb you. Just before the thought escapes me. The gentleman who's allegedly said to have been murdered or killed by Gwabeni. What was his name, by the way? Allegedly. Hey. Zungu says, according to Zungu says to Gwabeni, hey, wena usaphethe na ibhamu lapha. Angithi wena ubulele bani. Hey, we forget this evidence.
No, I remember that part of the evidence.
You are busy with a firearm here. Didn't you say this 38 you used it to kill so and so?
He did, my
So
lord.
is there evidence like that, Mr.
There is evidence like that, my lord, but I cannot remember the name of the
Hello?
individual.
I also listened to the same evidence.
Yes. So what I want to know is,
confirm that
hello?
it is there as well.
It is there, yeah.
Yes.
Okay, yeah. So all I want to know is, they mentioned a person who is allegedly deceased to both of them.
It was a
Ubani
lady.
Snow, Ubani
It was a
Gamalaki.
lady. It's the name of a lady.
It's what?
Snako.
Snago.
Yes.
Right. That's why it's Snuku. Snuku. So Snuku supposed to be a deceased, according to Zungu, by 38.
Yes, my lord, yes. I now
No,
recall
I'm
that.
interested in, because Mr. Mumalo says there was no meeting like that. When he submits that there's no corroboration, because there is corroboration of a name at least, of a person who's allegedly dead, and both parties know about that person. Am I correct?
Correct, my
I'm
lord.
summing up that.
Yes, my lord.
Okay, fine. I'll check it out in any case.
No, I recall that name, my lord, but this Sinako name comes
Yeah,
twice.
apparently he attends school, this guy, blah, blah, blah.
There's a Sinako that
Yeah.
I think when accused number 5 wanted to reverse, he asked him to inform Zungu that can he make
fine.
way. So I'm not sure whether it was that the same Sinako
Yeah,
or
fine.
it's another
I hear you.
Sinako.
Okay.
Paragraph 31.12, there's no duty upon the state to call every available witness. The state has made it plain that position of Ms. Kelly Kumar will be considered after the conclusion of this case. Hence, she was not called as a witness. My lord, we have made Ms. Kelly Kumar available to the defense and other witnesses that we have not called at the close of the state case.
Okay.
Paragraph 31.13, response to paragraph 16 to 18 DNA. Captain Masetla testified that in DNA analysis, you either include a suspect if his DNA is found on all 16 DNA regions, i.e. a full profile. If not, you exclude, and that there's no partial inclusion. He found a mixture of a DNA on the head, and accused number 4 could only be read in 4 out of the 16 regions. The finding is therefore neutral. Paragraph 31.14, at paragraph response to paragraph 23, joint possession of firearm. The test for joint possession of illegal firearm and ammunition is well established. The mere fact that the accused participated in a robbery where the co-perpetrators possessed firearms does not sustain beyond a reasonable doubt that the inference that the accused possessed the firearms jointly with them. That was held in State v. Nkosi, 1998, Volume 1, SACR 284. It was the decision from the Western Cape. Oh, Witwatersrand, my apologies, my lord. Witwatersrand Local Division. It was held that this only justifiable if the factual evidence excludes all reasonable inference other than A, that the group had the intention to exercise possession through the actual detenter, and B, the actual detenter had the intention to hold the guns on behalf of the group. Only if both requirements are fulfilled can therefore be joint possession in involving the group as a whole. The court in State v. Mbuli, 2003, Volume 1, SACR, on page 97, Supreme Court of Appeal, pointed out that where the offense is possession of firearms, or in that case a hand grenade, it is not the principle of common purpose that have application, but rather those relating to joint possession. A conviction of joint possession can only be competent if more than one person possesses the firearm. The court found that the mere knowledge by others that one member of the group possessed a hand grenade, or even acquiescing to its use, it is the execution of their common purpose. Paragraph 32, it is submitted.
Sorry, just hang on. Do you differentiate between between a conspiracy and common purpose? Have you checked that? Because people just talk about them like they're synonymous. A conspiracy and common purpose. And also it can include prior planning. You don't, these two concepts, you're saying they're synonymous. So
You mean they're the same?
you use inferential reasoning anyway, you have to, because it must come to the knowledge of the participants who are less than 2. I mean,
Indeed so, my lord.
at the most, they are 2 plus. They plan, allegedly. And that knowledge of the planning, they are bound by it. Because, as it is said, that they want to execute a particular project. And if they don't divorce themselves from that project, are they not bound? It's because Mr. Momalo was using Ngedezi. Ngedezi, is it not narrow? If you use the other cases, I'll come with them. If you use other cases concerning
Common purpose.
common purpose and conspiracy, you can be involved in a conspiracy and not be present at the scene. And you can also be involved in a... No, it's the other way. You can be involved in a common purpose and not be at the scene. Is that not so?
That is so, my lord.
Sometimes you can be involved in a conspiracy and also not be in a scene.
In the scene, that's correct.
So when you say if a person is not at the scene and yet is involved in a conspiracy, are you excluding him even for conspiratorial purposes, or how do you reason it?
I think it's the manner in which we use the words interchangeably.
Interchangeably, okay,
Yes.
fine. I hear you.
Physical, please. In paragraph 32,
Okay.
it is submitted that the application for discharge ought to be dismissed. And that is the end of our... Apologies, my lord.
Yeah.
Yes, Captain, my lord, just been reminded also to just place one aspect before I pose regarding the first appearance of this matter at Boxbeck Magistrate Court. That is on Exhibit EE, that is before court now. Accused 3, and I'm not quoting him verbatim, my lord. He says that when this incident of the 26th of October happened, he was, or they were incarcerated, which is in direct conflict with what we have seen in this matter. The Exhibit S, what Ms. Pinky Fillingham has told the court, what he has said through his lawyers, Mr. Mnisi, as well as Mr. Ngomalo, that they were enjoying this joyride in a Kumbi with Sigayo, Falcon, Pelimpidon Daonde and others. He was not in custody. He was outside when the deceased was shot and killed. That was his first.
Where do you get that evidence?
Exhibit EE, my lord.
EE, what does
That's
EE
correct.
say?
It's a transcribed record of the first appearance at
Yeah.
Boxbeck.
Who was making that declaration?
Accused number 3.
Through his attorney. Sorry.
Himself,
Senzo.
personally.
Hello?
He made it directly to the court.
Oh, personally.
That's correct.
He
That's-
tells the court, when this thing happened, I wasn't around Joburg.
I was incarcerated.
Or Gauteng, I was incarcerated.
That's correct. The record is there. It speaks
it's
for itself,
recorded.
my lord. We have the transcribed record is before
No,
court,
fine,
my
fine.
lord.
No, I just want to know if it is, then I'll check it.
That's correct.
And Mr. Ngumalo, what does he say?
No, it can't be checked.
Hello?
It can't be checked later. It must be checked now.
No, you don't know about that.
No.
Okay, fine. If you don't know-
I've never heard.
If you
it.
don't know about that,
No, it's
fine.
news to me.
Okay, it's news.
May I also make a follow-up, my lord, because
never
it affects my client very directly. The court will note that this is not a time to introduce new evidence.
It's not new evidence, Mr. Mnisi.
Uh,
If it's recorded, wait,
I
wait.
am not saying that
If
this
it's
is new
recorded
evidence.
before Mr. Ngumalo started addressing this court, it can't be
Yes.
new evidence.
My lord, I am saying,
Yeah.
and if the court can hear me, and please
Okay,
hear me
yeah.
well, please. I'm saying this is not a time to introduce new evidence. And that information that Advocate Sibanda says before he sits down, he wants to introduce it, should have been information, had it been brought to our attention. If that was the state's case all along before they closed their case, definitely that information would have been a subject of a trial within a trial to determine the circumstances under which accused number 3 allegedly said all those, whatever it is alleged that he said it. But now that he says it now, my lord, and now that it is said that he said it then, but that information is being introduced now.
No. You're talking at process purposes. According to your colleague here,
Yes.
the doctor, he says this was said at the first hearing.
I'm going to
it's
request-
like a plea. It's like a plea.
Yes.
First day you plead guilty or not guilty, and you say not guilty.
No, it can't be like a plea, my lord, because there's a specific format that prerequisites that lead to a plea. In other words, precursors to a plea. They explain your rights to legal representation. You make a decision whether you're going to conduct your own defense, whether you're going to be assisted by legal aid, or whether you will have your own attorney, and the implications of you saying something. That must be explained to you. So we don't know if those circumstances before accused person actually uttered what it is alleged that he uttered, those circumstances were explained to him, which is the reason why I say, if the state wants to rely on that information, it should have been something that was brought to the attention of accused number 3 in conjunction with me, so that we map a way forward as to the admissibility of that information. But as is now, that information is totally inadmissible. Unless it should have been a subject of a trial within a trial, my lord.
Let's hear Doctor, what are you saying? They say you can't use that information.
I'm accused number 3, my lord.
Yeah.
The request to see me.
Okay.
I'll wait for Mr.
Yeah, hello?
I'll wait for my colleagues.
Okay. Have you read of a case called State versus Nkoshe, 1949? Anything, that decision says basically, anything which says by counsel or his word in court, it's recorded.
That is correct.
Everything. 1949, so I was 2 years old.
I was 5 years old.
Yeah. Yeah, okay, let's hear. Yeah.
I'm instructed by my client that he would want the record of the 26th of October. Sorry, not 26th. Of the 27th October 2020 when they appeared in Boxbed, because to him it's news.
Yeah,
News. I've also never heard about that. Thank you.
As it please the court.
We've got it, that record. You remember there was a dispute about what the magistrate should have said and didn't say. And then somebody brought the typed record. Is that not so? Of the 7th of July. 27th July, sorry. Yeah, you're right. Okay, fine. So you want to see the record? They say they want to see the record.
The charge sheet.
The record?
The charge sheet of reflecting the date of the 27th of October
Okay.
2020.
Yeah,
But
fine.
I thought,
Boxbed.
This is mine. Oh, this is.
I thought Mr. Maramusipil will bail me out as an attorney because this when we introduced the information, it pertained to his client, and it was discovered during trial within the trial when we were dealing with the issue of. But when we introduce a document, we do not say this document only binds this one. It's a document before court. You can use it anyway, anyhow you want. The document was disclosed. Mr. Ramusipile can bail me out. I trust him to do that. He knows.
He knows.
Yes.
No, but it doesn't answer to our concerns. Still.
We cannot just disclose a document, my lord, to Mr. Ramusipile. We disclose to all of them.
Okay, fine. So,
But if they want the document to be disclosed, I can email it to them now, or we can print copies.
Yes. Print the entire.
But for now, my lord, I'm going to read what accused number 3, said.
yeah, okay, fine.
But before I do that, because I know this court wants authority,
Yes.
so I'll start with the authority.
Yeah, fine.
Section 235, subsection 1 of the Criminal Procedure Act, proof of judicial proceedings.
As it please the court, my lord. That is exactly what I said. This is an application for a section 174. This is not a time of losing evidence. And this application has got to do with accused number 4. If the state wants to reopen their case, they are welcome to make an application and say, having traversed the application in terms of section 174, there is this other information that we also want to introduce that relates to accused number 3. May we kindly reopen our case? But things cannot be done haphazardly the way in which it is suggested that they should be done here, my lord.
I haven't heard what Dr. Sibanda, I don't know what he wants to say.
No, he says exactly what I'm
let him
explaining
repeat-
to the
let him
court,
re-
my lord.
let
He
him
wants to
say-
introduce this new evidence.
Let him say what he wants to say. I don't know what he wants to say. What do you want to say, sir?
My lord, I was just making my last submission to say this is what accused number 3 said during the first appearance, and then there was this.
And then you said that you wanted to quote something.
I wanted to quote to say, but this evidence already is before court, and then it was brought in terms of this section, proof
Yeah,
of
so
judicial
let's
proceedings.
tell us, educate us about that section.
Section 235 subsection 1 says, it shall at the criminal proceedings be sufficient to prove that original record of judicial proceedings, if a copy of such record certified or purporting to be certified by the registrar or clerk of the court or other officer having the custody of the record of such judicial proceedings, or by deputy of such registrar, clerk or other officer, or in the case where judicial proceedings are taken down in shorthand or by mechanical means by the person who transcribes such record proceedings, as a true copy of such record is produced in evidence at such criminal proceedings, and such copy shall be prima facie proof that any matter purporting to be recorded thereon was correctly recorded.
Okay.
That's it.
And so what was recorded according to you?
And then I want to place on record what was recorded. And I'm just placing that relevant passage. Accused number 3. Okay, I'll start with the court. No response from accused 1. Accused 3, Mr. Mnube, do you wish to respond to the explanation about legal representation? Your Worship, accused 3. Your Worship, I do not see the necessity of having a legal representative because I do not know why I was brought before court. I will not enter the accused dock, Your Worship, because I do not feel, then there was no recording. Your Worship, the police officers, they were with other people. They came to us. It is alleged that at the time of the incident that we were outside, and it was later discovered that we were actually incarcerated. On actually what had happened, and that again, Your Worship, and decide as to what happened, and again, Your Worship, our constitutional rights had not been taken into consideration in that regard. So even at this time, Your Worship, they are not taking our constitutional rights into consideration, and that we, the people who actually committed that offense, they were outside, and that time we were incarcerated.
Okay.
And the date of this was 27 October 2020, and what I was reading is on page 4 and 5.
Yeah, fine.
Then I will pause here, my lord.
Okay. So what do
I
what
will
do
now
we do?
hand over to Advocate Baloyi, my lords.
Yeah. Oh,
Yeah, go please.
I thought Mr. Ngumalo wants to respond. You said you wanted to respond to the Makalani. Yeah.
The interpretation first.
Oh, the interpretation first. Okay, fine. What's the time now?
I don't think this whole
I
the
don't-
state took the whole day. I don't think I can do it in 30 minutes, my lord. This
Oh, so you suggest we do it tomorrow morning?
tomorrow I'm in Joburg High Court.
Well, somebody's coming here, is it not?
I would like somebody to come, but he asked me to assist him because he struggled yesterday with this document.
Oh, is that so?
Yes, that's
So, Joburg, are you presiding there also?
my lord. It's a recruitment. We are pressed for recruitment.
Is
We're
it?
even working this past weekend, Saturday and Sunday.
So that
So
gentleman...
the principal is on sick leave. They asked me to come and stand in for him in shortlisting. But on Thursday,
When
I'll
I
be.
make this submission, it is very unfair for the interpretation not to be done from the morning when the submissions were made. And reference have been made with our clients. They don't even understand what has been said about them. And then now the matter is going to be adjourned when they have not been following the proceedings.
I thought he said he'll read the two documents. That's what I thought you said. Yeah, well,
No, I was just saying, in fact, confirming what my colleague is saying, because I could hear them saying, "Asiz T1," meaning that they don't understand what is going on.
It is true, my lord, it was said. I think there was an agreement that Mr. Numalo the state should go, and then at the end, I agree that was. But if they want to do it, I can go. I was only saying the time. But if it's a concern, I can then do the 30-something pages now.
yeah, fine, please do that.
Okay.
And you must read everything on those pages. I need to understand
It's in English.
Yeah, and then you
I
interpret it into English. Okay. So which document are you reading now?
It's the reply from the state, my lord.
The reply from the state.
I don't know whether Mr. Numalo's one was done yesterday, I don't know.
It was done.
It was done yesterday.
Yeah, yesterday there was a,
No, it's fine. It was done yesterday.
it was done. So interpret the heads of argument of
By the state.
the states. Eh?
7 page
Oh.
4. 7 page 4. The judge is 7 page 4.
You know, to be fair, let's do it the other way around. When you read it, just start by saying state submissions, re-application for section 174, Act 51 of 77, discharge, application by Mtotokisi Mapisi, accused number 4. Lena impendulo is this one. Then you do it in Zulu. So you read English, thereafter you read Zulu, so that nobody can say, awuzwanga or atakazwanga in. Okay, let's do it that way. We interpret it same time. You read it in English, you interpret it same time, just like that, until we finish that document. Okay. I see you're smiling, Mr. Are you?
No, don't say that. No, I was having a concern, my lord, that it was done in English. It went through in the English version by my colleague, Dr. Sibanda. So he can just interpret.
No. Let him do it the way we should do it. You read the English heads and then you interpret them into Zulu. Fortunately, every gentleman here is Zulu speaking, so it won't be so to Zulu. Yes, sir, you may start.
I've never done it the way the court says I must do it, my lord. The court is making it difficult. I've never done it that way, my lord.
What's the difference?
It's already in English, I must just do it in isiZulu, my lord.
No, just do it the way we suggest you do it. Because they won't know what are you interpreting. Because these gentlemen, they can hear English. And I repeat, I once had a gentleman telling me that he certifies document in Rustenburg. He takes that document for certification. And I told him there are very few judges who can express themselves like you. So it's law. So read it for them in English and then interpret it in Zulu. And that's how we should do it.